Thank you, everyone, for joining today's training on human resources and doing the right thing, best practices for employers in 25. The training is partially funded through our USDA Rural Community Development Initiative training grant. And our presenters today are Amy Reasner and Holly Corkery of Lynch Dallas PC Law Firm in Cedar Rapids. And just to give them enough time, I'm going to go ahead and just turn it over to them and let them get started. Thanks, ladies.
Thank you. I wish I had a cute family photo to share, but I don't have children as adorable as Holly's, so I'm not
That
going to
is cute.
bother. I don't have children at all, much less as adorable as Holly's. So Holly and I are both employment and labor attorneys here at Lynch Dallas PC, and we very much appreciate you all inviting
Wrong
us.
screen. Sorry, guys.
Okay. I just thought you were giving us a cuteness factor
No,
here.
my
We should say that
where's the
Holly.
screen?
Yeah, Holly's had a bad start to her day. I was on vacation last week, so that means Holly has to, do all her work and my work. And then she managed to drop her blow dryer in the toilet this morning, so her day can only go up from here, I think.
Yeah.
Well, what we're going to do is we're going to run through these slides. We are trying to save some time at the end to ask questions, but if you want to drop a question in the chat, we can try to keep an eye out for that and answer them on the fly. Since Holly and I will be trading back and forth, we'll hopefully be able to manage that. So do the right thing, prioritize best employment practices. Shout out to Maddie Hunsinger, who is our associate, who helped us put this presentation together based on a variety of things that we experience every day of our lives as employment and labor attorneys. So our goals today are discussing the basics of employee hiring and providing tips to avoid liability, learning the policies and procedures that every employer should have in place, and then reviewing employee discipline and identifying common issues that arise for public employers. And obviously, same issues apply to private sector employers, but you just have some unique components to public employment that we need to address. So let's start with employee hiring. And one of the most important aspects of employee hiring is the job description. If you think about it, it's kind of a dual-edged sword, right? It's you defining what you expect from an employee, but it's also helping the employee understand what is expected of them and understanding, the essential functions of their job. So I often run into this in litigation, and I'll tell you how it pops for me. It pops in a couple of ways, and Holly can weigh in. But someone will call me and say, we have this employee and they're really not performing and we want to get rid of them. But they're just coming back from fill in the blank, a shoulder surgery from work comp, having a baby on Family Medical Leave Act leave, whatever the case may be. And I say, oh, okay, well, let me see their job description. And they say, we don't have one. And I go, okay. So we're then scrambling around trying to figure out, well, what essential job functions were they expected to perform? Did they know that they were supposed to be performing those job functions? So have a job description. It doesn't have to be the great American novel. It just should have an accurate picture of the title, to whom do they report, and back up just one, Holly, for a sec.
Oh, sorry.
What are the essential job functions? What are the qualifications? Really important working conditions, including mental and physical requirements. That's going to go to what I just said about somebody coming back from a shoulder surgery on work comp. What is being expected of them physically, and can they perform it? And then we're also going to be talking about those essential job functions. What are really important, like why does this job exist versus the little things that they may or may not do. Most important are those essential job functions. Okay, next slide. So essential job functions, the EEOC, Equal Employment Opportunity Commission, says they are defined as, well, what did this employer say is the essential job function? Did you put it in the description? Did you post for it as essential when you put out an ad? The other factors are what does the person actually do in the position? It could say that you're going to regularly lift 50 pounds. Again, I'm going to focus on that shoulder surgery, but the person really doesn't ever lift anything greater than 25 pounds. That matters. So the position description could say that it's essential, but it's not really essential. And that factor is going to matter to the EEOC, the Iowa Civil Rights Commission, or a court. Does the position exist to perform the job function? So back to that shoulder surgery, the person who's supposed to be driving heavy equipment that takes 35 pounds of pressure to turn a steering wheel, that's their job. They are road graders, they're a truck driver. And if they have a lifting or pressure restriction that's 15 pounds, and they can't turn the steering wheel, they can't shift the gears, whatever the case may be, then they can't perform an essential function of that job. What is the amount of time spent performing the job function? So I remember one time, again, shoulder surgery, someone said to me, well, the person's got to, carry these items and they're 50 pounds and they have to deliver them here. And I said, well, how often does that happen? And they said, well, maybe once every few months. Well, that's not going to be an essential job function. Asking somebody else to step in every once in a while to deliver 50 pounds when this person can only lift 15 is not an unreasonable ask. Also, a factor in deciding whether someone's job function is essential is, are the other people who have this job description, do they perform that job function? And are there other people that we could shift that job function to? So let's say we've got a group of 10 employees and I'm making this up, an operator 1 and an operator 2. We're asking this person to lift X pounds and they've got a lifting restriction of far less than X pounds. Are the rest of the people who are operator 1s like them, do they have to do that? If they don't, then why are we asking this person to do it? And are operator 2s doing it? And could we shift this to another operator 1 or another operator 2? So all of these analyses are related to us trying to determine whether a position has an actual essential function related to it. And that will always come up in a variety of ways. I keep focusing on like reasonable accommodation, but it could come up with intermittent leave for FMLA. It could come up for work comp, etc. The essential job function is also related to the degree of expertise or skill that the function requires. So again, when we're drafting what is essential, we're thinking about these factors. If this is some sort of a function that doesn't take a lot of skill or expertise or knowledge, it's probably one that could easily be shifted to somebody else for a temporary time period. All right, next slide. So drafting an accurate job description matters to ensure compliance with these laws. And I've been focusing a lot on like work comp, FMLA, the disability provisions under both the federal and state laws. But there's also the laws related to the Fair Labor Standards Act and the Equal Pay Act. And I don't think we think about those as often as we maybe should. So under the Fair Labor Standards Act, why do we need an accurate job description? Well, is this position truly exempt from wage and hour law such that it's not overtime required? Well, all of what we've just been talking about are factors that would be analyzed in order to determine if it is exempt or non-exempt. Right now, I have a lawsuit pending in federal court under the Fair Labor Standards Act where an employer I'm defending said, hey, this position is exempt. And the employees and their lawyer are saying, no, it's not exempt. And what do you think is Exhibit A through this entire process? It's the job description. And it's us taking the job description apart and applying it to the exemption factors. So this position, for example, is an administrative exemption, right? So we're analyzing things within the job description like How much independent discretion does this position exercise? Does this position need to apply policy and procedure? Do they have discretion to deviate from policy procedure? So you can see how important it would be to have a very accurate depiction of what an employee is doing day to day in order to be able to defend why the position is exempt. And then under the Equal Pay Act, that is, am I paying people who are performing essentially the same job functions in the same working conditions on the same shift, reporting to the same management structure, the same? And if I'm not, why not? And how would a job description help me? Well, if the job description says that this position requires a college degree and you've hired somebody who doesn't have one, but you're making a deviation for that position, you could explain why perhaps you're not paying them the same as the person who's got the college degree. In an Equal Pay Act scenario, if there were specific certifications that you say are preferred in the job description, you could explain why position A is getting paid less than position B because they have met those preferred prerequisites. So again, in an Equal Pay Act case, job description would be Exhibit A. I haven't seen any chats come through with questions. Okay. So moving to the next slide, job applications. So remember, we're talking hiring right now, and we started with job descriptions. That's the foundational component for your hiring procedure. You also need, as a foundational requirement, an application process. And of course, with public sector, we are trying to meet Veterans Preference Act as well. So we want to establish a consistent procedure about how to apply, where to apply, when is being posted, and a review of profiles, etc. We want to beware of password protection laws for applicants in and out of Iowa. And I know there's a little asterisk there from Maddie about, making it difficult for people to get in and to apply, and then asking them to provide social media passwords and that type of thing is a really tricky area. And we'll talk a little bit more about that in just a second. Best practice: the employer can investigate social media when you're looking at a job applicant, but it should be if the account is public or where the employer learns the employee is mixing business in a private account. And I want to flag this. I think a lot of people anymore are using LinkedIn and Instagram, and they are blurring the lines between professional and personal. And so certainly you're entitled to take a look at their profile when you're analyzing applicants, but you should pull that function out of the decision-making process so that the person who's reviewing the social media is not a decision maker in the interview and hiring process. Hopefully everybody has a job application to begin with, one that allows people to provide their experience, and then also, as I said about Veterans Preference Act, their military background so that you can potentially apply that law. Next up is job interviews, and I'm going to turn that over to Holly.
Thanks, Amy. On the job application, if you don't have a job application, that is a requirement under Veterans Preference that all employers in the state of Iowa who are in the public sector have a job application. So just make sure that you are filling one out or having applicants fill one out for all jobs. So that would be an important thing to have there.
Again, Exhibit A, right?
Yep. Oop, did I go backwards? This is like the most Monday ever for me. Okay, job interviews. So, the next step in that hiring process is going to be the job interview usually. And as we go into the job interview, uh, that can pose some potential landmines if they're not done appropriately and if everyone isn't given some just basic training before they go in. So we want to avoid discrimination risk by making sure everyone well, by one, making sure that no one who has any sort of decision-making input knows anything about the protected class information when going in. So, as Amy was just talking about, when you're doing the social media searches, don't have anyone who's going to be a decision maker do those sorts of social media searches. That used to be my job before I was a shareholder here at Lynch Dallas, back when I used to know more things about the internet. Now I Snapchat and TikTok, I don't know any of it really anymore. But before all of those things I did. And so I used to look things up and find out, and then just kind of square them away. But in any event, when you're moving on to the interview, you should not ask an applicant, questions that are going to give you information about a protected class. And those questions can be tricky. They don't necessarily have to be direct, like what religion are you? Which, obviously I think we all can understand is a question we should not be asking in an interview. They can be less direct. Questions that I think can get us all into trouble sometimes, where we come from a good place or from a truly just concerned, wanting to work these issues out type of place are, do you have children, right? What do we, how do you have childcare? Those types of questions. Those aren't appropriate questions to be asking in a job interview. Instead, you can ask questions like, these are the work hours. Are you going to be able to make those hours work? And those will get to the same place, right? Because really, when you're asking about childcare, you want to make sure that the individual can get to work and perform at the times you need them. So, just asking if the hours will work will get you to that same place. Um, One that also comes up, I've seen come up that can be uh, kind of interesting is when you have individuals where English is not their first language, just asking about a language barrier or if there's any sort of language issue, that's not going to be an appropriate question either. Um, if they're able to speak English and communicate well, and they've answered that question on the job application, and they're obviously speaking English to you in that job interview, just because there is an accent or a different sort of dialect there, that's not going to be an appropriate question or path to go down in an interview. There's all sorts of questions like that. And I think the best way to deal with that is just making sure that everyone is trained on not asking those sorts of questions and having a list of appropriate questions that are the same for all applicants before you go in. I think having a direct conversation, especially when you all are dealing with elected officials who sometimes may not have any experience in doing job interviews before they sit down to do this job interview with this individual. So, just giving them some background on what this looks like. Let's stick to the questions here. We try not to deviate from this too much. And then making sure everyone has the same sort of questions is going to be your best course of action. There is one caveat. If someone has an obvious disability, or raises one, then you can ask questions about the essential job functions. So I think Amy always uses the example, if the job is tree cutting and someone walks in and they're in a wheelchair and they're not able to use their legs, you can ask how they're going to be able to like climb the tree and, be able to cut that tree, and if they're going to be able to perform those essential job functions. Best practices, ask each applicant the same questions, focusing on essential job functions, skill, education, and the candidate's adaptability to change. Again, I think the best way to do that is to just have a list of the same questions and to have everyone write on their form, their answers or, their thoughts as they're going on. If the candidate raises a protected class issue, note that they raised it, and then just move on to your next question and steer away from it. Don't dive into it any further. Um, that happens. That's happened in interviews that we have had here. It's happened in other interviews I've had. So you note it and then you move along. And then you're going to want to keep notes. And within those notes, you want to make sure that you're giving them to your HR employee, or if you don't have HR, that you're giving them to whoever maintains those sort of records in your organization so that you have them in one place. What we don't want is everyone's separate interview notes just floating out around among the city. We want to get those and get them retained in one spot. So if there's any issue where we ever need them for litigation in the future or for any other sort of issue, we have them, and it's easy to move forward with that. Okay. That's going to be it for job interviews, and then we're going to be moving on to background checks. I cannot see the chat at all with my screen sharing. So are there any questions? No?
I don't see any.
I don't
All
see
right.
any.
Background checks. Okay, so the Fair Credit Reporting Act is the first background check that we're going to talk about. I would never in a million years claim to be an expert on the Fair Credit Reporting Act because it is a very tedious regulation. So I know the basics of it, and I will work through the basics of it with you here over the lunch hour. But the key is, I think, to this is make sure that if you are implementing a background check that involves pulling credit reports, that you're working with an agency or an outside contractor that does this regularly. This is not something that I would dabble in because there are quite a few requirements in doing so. So the Fair Credit Reporting Act requires that as the employer, that you provide the employee, uh, the Fair Credit Reporting Act requires that the employer provide the credit reporting agency with a statement that the employer provided the employee with all necessary notices and disclosures, of which there are quite a few. So you'll want to sign off on that to them as required, and then you'll want to make sure that you're doing it. You are providing all of those, which again is why I would work with an outside contractor that does this regularly so that you have those processes all in place. It also requires that as the employer, you provide the applicant with a separate notice. So this cannot be part of your application. It's got to be separate, that the employer may use a credit report in its hiring decision. And then you have to receive written permission from the applicant for the employer to obtain the credit report. If you are going to make an adverse action against an applicant because of a credit report, before you make that decision, you have to provide them with a summary of their rights under the Fair Credit Reporting Act and then the report that you relied on to make that decision. You also must provide the applicant during the decision any adverse action notice with information of the credit report company. The credit company didn't make the adverse action decision, and a statement of their rights to dispute the accuracy or completeness of the report, and that they can get additional free report if they request that within 60 days. Now, if you work with a contractor generally that does this sort of a background check, they are going to have all of these forms readily available, and they are going to work through this process and kick these sorts of things out for you as the process goes on. So again, that would be my recommendation to ensure compliance.
And I would flag again, going back to that whole issue of the essential functions of a job. Why are you doing the credit report check, right? Is it related in some way to the position? And some of you clearly would have a reason to, if it's a position that deals with your finances, your bookkeeping, et cetera, you may want to run a position like that through the Fair Credit Reporting Act. I think it's typically more like banks and financial industry positions. But if you're doing it, we just want you to be sure it's job related, and that you're doing it correctly.
I think it would mostly be like any treasurer, city clerk, and any sort of city manager.
But you
That'd be
can
where I see it
also
most.
you can also find that probably more of what you need to know by running a criminal background check, which gets to the next point, Holly.
Yeah. So these are much easier in my view, but I still would recommend using a company to assist you. I know there are organizations that are still doing them, just having someone run on Iowa courts who's not a decision maker. Not the best way to do that. Iowa courts is confusing. Just, by you have to know the birth dates and all of that, and lots of people with the same names. So, I mean, having a company that knows what they're doing and can pull accurate data is obviously preferred. But a background check, Iowa law does allow us to do background checks on criminal history, but you do need to be aware if you're in certain communities, Des Moines and Waterloo are both flagged here, that there are ban the box laws where you're not allowed to do those sorts of background checks. If an applicant is discovered to have a criminal history, um, you can consider the following when deciding to hire the applicant: the nature of the conviction, the date of the conviction, and whether it's been expunged. There's quite a bit of EEOC guidance on this as well. And really, you should be making an individualized assessment related again back to the essential functions of the job and what the crime is, right? So if you have a 20-year-old, um, minor drug conviction, or minor possession of alcohol conviction, and we now have someone applying for, a Parks and Rec position or, a public works position, when we're looking at, this 20-year-old conviction, they've had nothing else in between. Uh, Everything's been fine. Nature of the position. If we're weighing that, is that really going to have any bearing on their ability to perform their essential job functions? I think you're probably going to be hard pressed to not hire them based on that 20-year-old, minor conviction on that issue at that point. Now, if you, on the flip side, are going to hire a city clerk treasurer who has a 2-year-old theft conviction, that's a little bit different. Definitely tied to the position. Very clearly, that is a little bit scarier. Likewise, if you're going to hire, a public works employee, CDL holder with a 2-year-old OWI, again, that would be more tied to the position. That would make me feel that you know, we could withhold the offer based on that background check. So we have these sort of individualized assessments based on the position and the essential job functions each time we go through a background check. And another thing that's always important as you're going through those is you want to, once you've gone through that individualized assessment, give that applicant the chance to explain, right? So in the example of the 20-year-old, we'll say it was an alcohol conviction, some sort of possession of alcohol conviction, right? Um, so say we still weren't gonna hire him because we're just extremely strict about these sorts of things. Well, it turns out, he really, he was just carrying a beer after a Hawkeye game because it was a hard loss, and he was in, it was just whatever. Well, that explains it, and we're all okay with it after that because 20 years ago was a bad decision, but we understand now. I don't know if that really made sense, but we allowed him the chance to explain it and give us, some sort of resolution, whether or not it made us feel that we could hire him or her, as the case may be. Uh, that you've got to give them the opportunity to do that. And the EEOC says that if you do that, then that would be the appropriate way to handle a background check of that nature. So those are going to be the important things there.
One of the things that's come up for me lately, I think, are just how somebody might feel about a past conviction, especially if you're in a community where people know about it. So let's say it was a violent crime. It still may be old, I would probably talk to my city attorney at that point. Violent crimes, sex abuse type crimes, where you may have to manage the hiring internally and where you may run some risk of a negligent hiring claim. So just play this out, if the person is someone who's like a building inspector or a housing inspector and they've had assaults of people, am I really going to want to be putting that person in other people's homes or businesses if I think there's a risk that it's going to happen again? So you can see how this would play out in a number of ways. And if at any time you're concerned about, well, how is this going to play out, you really should address it with your city attorney.
Another point that I want to raise, all background checks, whether they're credit checks, criminal checks, they always happen post offer. So when we're doing a background check, we do not do it until a conditional offer has been made. Then we do the background check, and then we withdraw the offer if we need to do so. So I just want to make sure that that timeline is clear for everyone and how we would recommend doing that. Okay, on to hiring checklist and back over to Amy for a bit.
Well, if you don't have a hiring checklist, you should get one. And this is just an example of things that are commonly in checklists. But you want to have something that you can tick off, that these things have been done. And you put most of this information into someone's personnel file, other than the I-9 information, obviously, which has its own separate filing. I guess on the other side, I would have a termination checklist, and we keep them both here at our own firm, and then I've helped create them for other clients as well. But it's just a good way of going through whether you've done everything that you're supposed to be doing to meet your government obligations. So now we're going to move to employee policies and procedures. And this ties in next step to onboarding that new employee. So you've gone through the hiring checklist. You've gone through orientation and training. That should include reviewing the job description, as well as, kind of their organizational structure. And then you're going to want to have them review and check off on the employee handbook, which would include, your acknowledgement form that's going to be signed off. It could be electronic, it can be paper, and put into the personnel file. So you want to especially flag for the employee when going through the employee handbook a couple of things. One would be if they've got workplace concerns, whether they're interpersonal, whether they're, concerns about discrimination or harassment, or their safety issues, they should be very clear in the handbook about where they're going to go with those concerns. Remember also that employees should get the most recent and compliant handbook. I've had some occasions where when I've had cases and something's gone awry and I'm looking at a handbook and it's from like 2006, right? So half the time it's devoid of things that should be in there, including like the Pregnant Worker Fairness Act, which is a pretty new law, or the Religious Freedom Act that Iowa passed a year or two ago. So make sure that when you're in a hiring process, it might be the time to check and make sure your handbook is fully updated and has all the policies and procedures that should be there. Employee handbook checklists. So again, we talked about the job description as having multiple purposes. That is informing management what is expected and informing the employee what is expected. That's the same for a handbook, right? The handbook should govern how you're dealing with your workforce, and it should give information to your workforce about where to go for certain information or who to see for certain information. So I keep a handbook checklist. I think you're starting to see a trend. I use checklists, probably because I've gotten to the age where I can't remember anything without a checklist. But we have a checklist here at the firm that we update regularly on what should be in, a handbook. Now, some things you don't need them, but there are certain policies and procedures that ought to be there. And for sure, every handbook should include things like apprising people of their civil rights and how they can report concerns about those or, again, safety issues. There should be policies in there about performance evaluation, hiring, discipline, obviously attendance, benefits, safety, and then property policies. Side note on property policies, especially for public employers, you should have a statement in your handbook explaining to people that your property is owned by the city. They have no expectation of privacy in it, right? Your desk, your truck, your locker, your email, your text messages on the work phone, your call history on a work phone, that type of thing, so that people are on notice that if they're misusing that property in some way, that you have every right to inspect it or to seize it. Holly, did you have something you want to say? No? Okay. Other common procedure issues. If you are an FMLA compliant city, right? So all public employers are FMLA qualified, but not all public employees are FMLA eligible. But if you are FMLA with a workforce of FMLA eligible employees, make sure that your handbook explains people's FMLA rights. The other thing that we see a lot procedurally for employers is they're not using the appropriate FMLA forms whenever this issue pops, or they're accepting incomplete or deficient FMLA forms. I know that FMLA, we could spend probably an entire day on FMLA, but I just want to flag this as one of the most common procedural problems. Don't blindly accept what someone has given you if you're not understanding it, if it doesn't apply to their essential job functions, if you're not clear on time and scope of an FMLA leave. And why does this matter? Well, first of all, we need to be able to manage the leave, right? If we don't know when the person's coming back or what's going on, it's going to make it difficult for us to plan operationally and then to plan to potentially accommodate them when they return. So what I see oftentimes is that I don't even know why the person was off on FMLA when it now comes back to me as a city attorney and I'm trying to help the employer figure out if the employee can come back and perform the essential job functions with or without reasonable accommodation. Remember also that all FMLA forms, paperwork, notes, medical notes, they all need to be in a separate file from the personnel file. Those should not be in a personnel file that's highly confidential. And that includes workers' compensation information as well. Next slide.
Remember too, when these employees are coming back from FMLA, right? Make sure, and you're making sure they are released. Like I'm working with an employer that just got one last week for a police officer. He's exhausted his 12 weeks of FMLA for an autoimmune situation. And now he's coming back to work and his restrictions are he can only work 5 days a week, 8-hour shifts, which that will violate the CBA. So that's a problem in itself. But the other problem is he can't be exposed to animal dander or tear gas. So he can't go into homes because we don't know where animals are, right? So, I mean, that's going to be an interesting interactive process discussion about how we can accommodate that, if he can perform his essential job functions or not. But, you know, you'll have those discussions when they come back with those, and these are forever accommodations. Well, some are for till June and some are forever. But anyway, you'll have those discussions as they come back, and they may not be able to come back. And those are things that I just flagged for you that, you know, those are important discussions to have and to work through with the employees as they come back. And they're important discussions to have because the call that Amy and I probably get top 5 most frequently is the employee like the one that I just flagged for you that's been there for 2 years and that no one knows really what to do with now because they've just kind of let them sit in this sort of limbo situation.
Right. And it's important to be able to show, again, procedurally, that we did everything we were obligated to do with respect to the FMLA forms, the paperwork we've asked for, the paperwork we've received, the job description that applies to us dealing with this person and their requested accommodations. So you can see how this all kind of goes together. Okay, another common procedural issue is we're unclear if an employee is exempt or non-exempt under the FLSA. We talked about having the job description and being able to use that to figure out if we're meeting an exemption test. And remember, right now, we've got both a salary level that they have to meet as well as a duty test. A common mistake is that people just say, oh, well, they make the threshold dollar amount, which has gone back and forth a million times, on what that amount is, but I think it's $684 a week. And so you don't worry about whether they meet the duties test or vice versa. And the real risk here is if you're not analyzing your job descriptions and the actual essential job functions, is that you're going to get a Department of Labor investigation that could result in you concluding that someone is owed 2 or even 3 years worth of overtime pay going back in time. And also, I've seen the Department of Labor decide when they've seen one employee complaint that they need to investigate the entire department and analyze everybody's job descriptions. And then in one case that I had, the Department of Labor pulled the entire department's exemption, and the employer was having to pay back pay for, like 30 people, as opposed to just the one complainant. You can imagine the cost of that. So again, analyzing your job descriptions, making sure that we're meeting both the salary and the duties test for the Fair Labor Standards Act, and ensuring that we're paying overtime where overtime is due if a person's not exempt.
Even if you've done all that too, like pay attention to what people are actually doing.
Yeah.
I sat down with a client last week and was chatting with them, and it's a smaller organization, and their police chief just happened to be, he's non-exempt just by the nature of the organization. And he was doing all of this extra work that he wasn't writing down. He was watching surveillance videos. He was apparently going incognito and surveilling, what he believed to be drug houses and never writing it down. Essentially trying to make himself a non-exempt employee. And those issues we can't have. We need people who are non-exempt to be writing down all their time. We need to be dialed in a little bit to what they're doing, and making sure that we're on that so that we're paying them appropriately. Ooh, discipline and discharge. Okay, so Iowa's merit system, this is on me. I'm going to skip this because this won't apply to cities. So we'll cross this slide out if you all have the slides. And then we'll move on to the next slide 22 that talks about if the position's non-merit, because that's where you all are going to be. So the employee would be considered at will. Most of your employees are generally going to be considered at will, but all public employees have like a minimum level of due process, which is really frustrating, I think, to people who are new to the public sector, because they will not understand why your employee handbooks have an at-will employment statement, and then you have to give them a Loudermill hearing or a due process hearing, however you want to call it, before you suspend or demote or terminate an employee. So while that is frustrating and I understand it's just how the law is. And all of the employees in the public sector are going to be entitled to that minimum level of due process. So you don't need to prove just cause. You're going to be able to terminate employees generally for any sort of lawful reason, but you've got to give them that due process hearing before you do so. I do have a few caveats to that I want to make sure that I have flagged for you all. If the employee is a veteran, then they're going to have a higher standard when you go to terminate them. They're only going to be able to be terminated for incompetence or misconduct. And that should be, when I sit down to start to talk about, a potential termination with a client, that's one of the first questions I have. Also, if the employee is appointed, which is a term of art in the law, you can look to your ordinances. Your ordinances will usually lay out who's appointed. Um, if they don't, well, they should lay out who's appointed. But if you're still unsure, you can look back to the resolutions when you brought people on to determine who's been appointed and who's not. And if you're unsure, it's always a good place to go look before you go to remove someone. But if someone's appointed, then they are entitled to a little extra due process. They have to be removed by a written order. And the written order has to be mailed to them via certified mail, and then they get a second uh, hearing they get a hearing in front of the city council in 30 days. So whether they were removed by the city council or they were removed by some other authority who appointed them, they get a hearing in front of the city council within 30 days if they wish. So I flagged those two things for you. And then the other thing I would flag for you is civil service. There are several bills, as there are every year, it seems like, in front of the legislature to amend the civil service section. So this could change come July 1, but for right now, where civil service stands is that cities can terminate, remove, demote, or suspend, or just discipline overall, really, a civil service employee for any act or failure to act that is in contravention of law, policy, or standard operating procedure, or that a management's judgment is unsuitable or unfit for employment. And the key is within the statute that the employee cannot be disciplined arbitrarily. So you'll always look to the conduct. As I'm working through civil service, for any of you that are civil service with any of my employers, we always look to see, okay, what have we done with other employees? How have we treated other employees in the past? Because, if we've let everyone else, if we haven't disciplined others for this, and then we're going to fire someone for this, that feels a little arbitrary, right? So, I mean, that's going to be our key thing that we're going, to look for, you know, first. And if your manager can't testify to that, then that's going to be difficult. If you've got some sort of, a lot of times in law enforcement and in the fire departments, they'll have like a discipline matrix that'll essentially say, if you, this infraction this many times gives you this discipline. That's especially helpful. That's not, that shows lack of arbitrariness, right? Because we've got it in writing where we go. So those sorts of things can be really helpful to prove that up if you have them in place. Before discipline, we want to make sure that we've been managing behavior and performance. So I talked for an hour on Teams about this morning. So we want to make sure that we are documenting things with employees. So we're starting small and we're just making sure that we're getting everything down on paper and we're documenting things with a date, right? Now, I'm not advising that we document every ticky-tacky little thing that every employee does ever, because that's not a work environment anyone is going to want to work in. I would not want to work there. I doubt Amy would want to work there. No one would. But you also can't be the type of manager that doesn't manage any sort of performance issues or misconduct until the point when you call Amy and I, practically yelling at us that you can't take it anymore because employee X is just driving you crazy. So we've got to find a balance between those two things where we are documenting the things that really need to be worked on. If we have a situation where an employee's performance is low, where they are just not getting done things they're supposed to get done, they are making errors. That is something I hear a lot. Attendance issues, attitude issues, those are performance issues I hear. Then we're implementing a performance improvement plan. A performance improvement plan is great. That forces everyone to document things regularly and get us all on the same page. If we've got misconduct, we can start with oral reprimands. We'll try to have meetings. We'll follow up with the meetings with an email always when we do that. I would always recommend having two managers in the meetings. I mean, really, if you have HR as a resource in your organization, having your department head or whoever's doing the discipline and HR there, that's ideal. Okay, I think I'm back to Amy.
Yes. We stuck this in here because what happens so frequently, if I had a nickel for every time it did, I'd be a multi-millionaire. Uh, you bring someone in to discipline them and they make a complaint. Or, they claim that they were hurt on the job, or, they claim that they're going to need to take FMLA leave because they're having a mental health crisis or what have you. So what I wanted to be clear about here is if you're in that meeting and you're trying to have this disciplinary meeting, you need to say to the person, I will deal with that separately. And you need to proceed potentially down the path of separately analyzing whatever it is that they're complaining about and then returning later to the discipline. Okay, so you pause discipline, take the complaint, listen for, are they talking about a protected class? Are they talking about a law? Protected class would be, I think my boss is picking on me because I'm a woman. I think my boss is picking on me because I'm 55 years old, whatever. I'm concerned that I reported a safety violation and now I'm being disciplined. Like all of those things, document, date, and say that we're going to follow up on that complaint. Because where we're headed there is you may still be disciplining later, but we still have to figure out if there's a viable claim here that needs to be investigated and resolved. So put the discipline on pause, investigate the complaint, figure out whether it's viable or not, and then head back to discipline. And why I say this is because if you just blow by that in the discipline meeting, they're probably going to claim that, well, A, whatever it is they're complaining about, and B, that you're retaliating against them because they made a complaint. And you don't want your discipline to be appearing as if it's tied to a protected class status or tied to a complaint, or that it's resulting because the person complained. Remember also when someone makes a complaint like this that we're talking about, you need to document it in a separate complaint and investigation file so that it can maintain its confidentiality for depending on where we're headed on that. I think we're also back up to due process again, and Holly has already talked about that previously, that the person may have the right to a name clearing hearing, right? That's you told me what I did wrong, I had a chance to respond, then you make your decision. But the person may also have a property right in their job. That is, you gave them a contract. You said that you were only going to discipline or discharge for certain reasons. Could be a union contract, could be an employment contract. Where those types of property rights exist, we need to follow the contract and make sure that whatever steps are in the contract, whether it's a grievance procedure or whether it's I'm terminating for cause or disciplining for cause, that you're following those procedures. If it's a union contract, the person is entitled to have representation during the disciplinary interview. This comes up a lot. People say to me, oh, they're not in the union. And I say, what do you mean they're not in the union? I'm looking at the contract. It says the position of fill in the blank, dispatchers in the union. Oh, but they don't pay dues. I hear that a lot. Does not matter. If the contract says the position is in the unit, then they are entitled to union representation, and you need to offer it to them to ensure that you're not getting a claim down the road that you violated their contractual rights. Ensure that you are following all due process and statutory requirements when disciplining. Holly alluded to this earlier about, is the right person performing the discipline? Who's the appointer? Under ordinance, is that the person that's supposed to be doing the discipline? We've already talked about having a witness. Employee as a veteran has different protections. And then, we've talked a lot about these other issues. In the end, is the employee in a public safety unit and entitled to Peace Officers' Bill of Rights protections? And in that case, you may have an entire other set of procedures that you're going to have to follow that Holly will talk about shortly.
Okay. So if you discipline an employee, they could potentially file an appeal. If that happens, you should call your own attorney because timelines will start to run no matter what the appeal. If it falls under civil service, if it falls under an appointee's appeal, if it falls under veterans preference, um, also if it just falls under your handbook, right? Like sometimes people will make a grievance handbook appeal. It could also be a grievance procedure under your collective bargaining agreement. So we're going to collect documentation used to make the decision to discharge the employee, including the personnel file, which is why also we keep everything, in one spot. As we talked about at the very beginning, that's always very helpful instead of having things floating in different places. And then we're going to be particular as to the charges raised for termination or discharge and the instances which precipitated the charge. So, or the discharge, excuse me. So we want when we're writing a termination in the public sector, and this would be true of the private sector, but I think especially in the public sector, it's always really important because there's so many appeal rights to tie it. This is the thing you're accused of doing, and this is the policy you violated, right? So like really like it just works down like a two-part always, and we just want to have it very clear how it is. This helps not only with all these different appeals, but it's also going to be very helpful in unemployment because unemployment is always going to want to know what policies were violated. We want to avoid claims of retaliation always. Having that very clear policy that was violated is helpful as well because part of retaliation, when we shift back, there's an initial burden on the employee, but in the test for retaliation, we eventually shift back to the employer, and the employer gets to prove a legitimate business interest. And if we can prove that there were actual legitimate policies that the employee was violating and that we have an interest in upholding, that's helpful to us. So another reason to do that. But federal and state law prohibit us from retaliating. We can't terminate an employee because they're exercising a statutory right or they threaten to exercise a statutory right because they're engaged in any protected activity, really. So if an employee makes a complaint, you cannot fire them because they made a complaint. If an employee threatens to call OSHA, you cannot fire the employee because they threatened to call OSHA. Though, I mean, these are just examples that come up, frequently for us, but things that you cannot do. Um, Even though you cannot do that, you can still discipline employees when there's well-documented issues and discipline is for the right reasons. So even if you have an employee that threatened to call OSHA, if 1 month later they, I don't know, violate a whole bunch of policies and just do something completely egregious. I'm not creating enough of the story to come up with some good story off the cuff, but you could still discipline them for that. And you're going to be okay to do that, right? And especially because when they threatened to call OSHA, you probably investigated that issue and sorted it all out from the beginning, putting that to rest anyway. But then we're going to separately go off and deal with this disciplinary issue that comes up on the 1 month later down the road. You can still do that. You just very carefully have to document why you're disciplining the employee. And again, make sure that you are very carefully tying that conduct that you're documenting to your policies the employee is actually violating. It will also be very important that you are making sure that other employees have also been disciplined for this type of conduct. If you've not disciplined employees for that type of conduct in the same situation or a similar situation, then you're not going to want to do it there. Okay, Peace Officer Bill of Rights, Iowa Chapter ADF. I'm not gonna belabor this because I'm not sure. Are we at Do we have 15 minutes?
Yeah, but we're going to leave some time for questions.
Questions. Okay. Well, I won't belabor it still. But what you need to know about this is if you are getting ready to investigate a complaint involving a police officer, if you receive a complaint involving a police officer, or if you're going to discipline a police officer, there is a decently long statute of rules that you have to follow, and that's Iowa Code ADF.1. And unless you are feeling very comfortable with that, my advice would be to contact your city attorney to help you wade through that. Some police chiefs are extremely comfortable wading through that. And if yours is, that's awesome. If yours isn't, or if you are investigating the chief or you received a complaint against the chief, then I would contact the city attorney.
And just a quick note, I think people always apply this to just police officers, and it includes firefighters, EMTs, correctional officers, detention officers, jailers, blah, 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 public safety telecommunicator, also known as a dispatcher. So you need to be sure that it's being applied in all cases where someone's falling under Chapter ADF.
Volunteer firefighters.
And including volunteer firefighters. I would know because I just had to deal with that last month.
But the good news is our Supreme Court clarified about 2 weeks ago there is no private cause of action under Iowa Code ADF.
Not the way it's written. And basically they also said it was written very poorly. Just if you want to take a read through the Supreme Court's scolding of the Iowa legislature.
I don't disagree.
Yeah.
Again, this is Iowa Code ADF again. All of the rules that are included in ADF that you have to follow, 2 slides. So, not to belabor it. We will take time for questions, as Amy said.
Holly and I have a bet that the first question will be FMLA. I'm not telling you who bet who, so just know that I'll win if you send an FMLA question.
Oh my goodness.
I would say while we're waiting, I spend most of my time right now on Family Medical Leave Act, Americans with Disabilities Act, and work comp interplay. Probably 50% of my contact is related to those issues and people trying to understand the employee's rights, the employer's obligations. I will tell you, I think that most healthcare practitioners absolutely despise filling out that paperwork. They think it's intrusive, and they're the ones that have a very good relationship, right, with their patient, and they feel like they're participating in getting the person in trouble. But remember, this is not about getting somebody in trouble. This is about ensuring that an employer has all the right information to potentially help someone, to grant a leave to them, and then to bring them safely back to work. So I always tell people to make sure you're explaining to the employee the purpose of these questions. And I've had to say, to some people, we don't want you hurt, we don't want our co-workers hurt, and we don't want the public hurt. Because a lot of times that's what we're talking about. I'm running into folks like who may have unmanaged diabetes, who are passing out, who have high blood pressure. We don't want them driving trucks or police cars. We don't want them operating, backhoes or handguns when we're not sure that they can safely perform those essential job functions. And if the employee is a good employee, you are doing everything you can to try to protect their job, to try to help them get the time off that they need, but to also protect the employer, because in the end, it's a balance of those things, right? Oh, come on. Now no one wants me to win the FMLA.
You already lost. Annette asked a question about unemployment.
Oh, yes.
The question, what?
And I see even one of our own clients didn't help me out here. Okay, go ahead.
So Annette asked, I recently terminated an employee for performance and sat through the unemployment hearing only to learn that the person will get unemployment because they didn't do anything malicious that caused the termination. Is it worth trying to appeal again? Well, the answer is it depends. So unemployment has very specific administrative regulations about what qualifies for misconduct under the code that would disqualify you from unemployment. So I think I would look at those administrative regulations. And if you needed help doing that, you could ask your city attorney. We could try to, I mean, if it's not like tomorrow, I could find them and send them to you. But if it's tomorrow, I can't really, to be honest with you. So, I mean, but I would go through those, and if you can square it within those, then yeah, I would try to appeal. But all right. So if you can do it tomorrow, I would try to, or if you can do it and square it within those, then yeah, I would try to appeal. But if you can't square it within those, then yeah, I think it may just be one of those things where yes, you met the requirements of terminating this employee, who's an employee at will, but we just didn't meet the threshold to not get them unemployment, which there's some room in between there. There's daylight there.
We did have a question about an update on how the new child labor laws will impact seasonal positions. And yeah, we need to take a look at that. And what's also going to be interesting is what happens with the US Department of Labor. Because remember, we had a tug of war between Iowa and the US Department of Labor under the Biden administration. I've had a couple of cases where employers were under DOL investigations that have now stalled out. So we may potentially get some alignment, I don't know, with USDOL and Iowa, but we can certainly send out an update on the new child labor laws and flag for you that we doubt we're going to have quite the level of scrutiny from USDOL going forward. Holly, we should have Maddie do a blast out for everybody.
That would be good.
There's a question also about union pay differences. Is it allowed for a city to pay someone under the same union but different departments more due to needing to be licensed over their counterparts in the union? Well, the first question is, what does the contract say about whether you can pay more for a certification that's required or a license or what have you? So the plain language of the contract is going to apply. If there isn't anything in the contract about, essentially supplemental pay for a license, then that's something that if depending on the type of bargaining unit, right? So if it's public safety, they would have the right to bargain that type of supplemental pay. But if it's not public safety, they don't have the right to bargain supplemental pay. And this is, if it's not a base wage issue and it's a supplemental pay issue, then that's where you'll have the applicability of what type of unit, right, Holly?
Yeah.
But would it be a legitimate, non-discriminatory reason to pay someone more? Yes, it would be. But the union contract issue is going to complicate what you're hoping to do there. Anything else? Well, Tricia, we really appreciate being invited to do this. I know not everyone wants to spend their lunch hour with lawyers on a Monday, especially.
No, thank you. We really appreciate it. Thank you, Amy and Holly. It's been wonderful. I think everyone really benefited from this. And I will send out, if you don't mind sending me the PowerPoints, I will email them out to everyone, along with a little survey just to get some feedback. And then I'll share that with the two of you as well. So
That's awesome. And we do want to be very clear. We appreciate getting feedback on both substance and style. If there's something that I'm doing or that Holly's doing that you wish we didn't, please let us know. We're lifelong learners. We're willing to change.
great.
Just remember that I did start the day with my dryer in the toilet. So
Yeah,
Tuesday.
that sounds dangerous.
You could start me on the curve, guys.
Poor thing, Mondays.
Yes, we will send you the slides and you're most welcome to share them with the group.
Great, thank you. And I also have recorded the session, so we'll be posting that out too, if that's okay with both of you.
Absolutely.
Thank you.
Yep.
All right.
All right.
Great. Well,
Thank
thank you.
you.
Hey, everyone, have a great rest of your Monday.
Yeah.
All right. Bye-bye.
Bye
Bye.
bye.